make him pay. Yea, the judge from the bench today. No more lies, corrupt decay. Yea, the judge, watch him sway. Truth will rise, make him pay.
Today will today be Yeet the Judge Day? I have no idea. You have no idea. But the last thing yesterday was Attorney Steele handing over the papers to the judge and then complimentary copies to the prosecution. And that was the end of the day. So Judge Glanville have had all night stewing on this. Now, I will agree with Strinton here. Judge will punt it until ordered by the Supreme Court. Yep. It's his standard. Let's wait to the end of the trial, and if the appeals court says I'm wrong, then I will listen to that. That is his standard, because he knows damn well that this trial will be going on another year. And he knows that appeals are expensive AF, especially since in order to appeal, you need to get the transcript. And we are talking about, just for the transcript alone, it's $1 million. It's because it's so much garbage. So much garbage. So much unnecessary. And I'm starting to realize that this is a tactic from the prosecution. If they prolong this as much as possible, soon the only person who can afford is young thug, Mr. Williams. He's probably the only one of the remaining defendants, of the 6 defendants in this trial, who can afford. Which means if Shannon Stillwell gets convicted, then he might have to rely on public defender's office to do the appeal. That's a good decade before that's happening. So the only one with a serious chance of getting an appeal within a decade of this trial is young thug. And I'm sure that, but the more of this, the bigger the chance that sooner or later either the appeals court or the Supreme Court in this case have to intervene. Eggs kommer for Norwegian 50 krona. Soon midsummer, Nick. Will you dance around the pole without clothes this year? No, I will not. I have neighbors that are married, and I don't want to break up their marriages. Thank you so much. And Also a member for 4 months. Thank you so much. That is so, so very nice of you. My accent made it sound like you said PIN code. Okay. Well, my accent makes me say very strange things that YouTube sometimes don't. Oh, did he say that word? No, it's the accent. Did he call Judge that? No, YouTube's. It's the accent. I promise. Well, so we are, as per usual, waiting for today's trial to commence. So, what we will do, as a treat now in the beginning, we will read Attorney Steele's motion to disqualify or yeet the judge. He has a motion of off you 2-hour word. And let's see here. Where do we get it? There it is. There it is. There it is. I can make that a bit bigger, can't I? There, so everybody can follow. Are you ready? Are you ready? In the Superior Court of Fulton County, State of Georgia. State of Georgia v. Jeffrey Williams. Indictment. Motion to disqualify / recuse Judge Glanville from all further dealings in the above reference case, and motion for mistrial, which was goaded by the improper conduct committed in concert by the court and prosecution. In lawyer speak, this is you need to be yeeted because you're corrupt. That's very nice put. Very nice. Hello, Metalcore. It's Trinton, Quill, Tree Thib, Reformed Convict, Stace Patton with Daisy Williams, Samantha Yo. I saw Teresa Rice, Brooks Alexander, Joy First Fan, Jasmine Hall. Who else was here? Well, a bunch of people. There's a good bunch of you here for the first 10 minutes. Usually it takes about 10 minutes for up to half an hour sometimes before. Ooh! Nick, the one without powder on his nose, is streaming. Quell asks, is it true that a mistrial declared at this point with the prosecution of misconduct might mean double jeopardy attaches? Maybe. Mistrial with prejudice has to be declared in order for double jeopardy. And say that the judge declares mistrial without prejudice, then it all starts over. But if he then is disqualified, that means another judge will take over this, which hopefully will mean proper rules in a courtroom, proper rulings, maybe even a bond hearing that is successful. There's so much that can be better with another judge. But it's still a coin flip. It's still a coin flip with that. So it has to be with prejudice in order for double jeopardy to apply. And that is a extremely high bar to set. Extremely high bar to set. Diogo's here and Hellraising Angel. Am I a real life Viking? This is the 1,000 years of successful inbreeding. Can I say I'm a real Viking? No, nobody can anymore. Nobody can anymore. But I've traced my ancestry to somewhere in the 12th, 13th century. So it's close. it's close. But nobody alive today is a real Viking. Just saying. But this is probably as close as you can get. But let's get back to reading this. Comes now. Jeffrey Williams, by and through undersigned counsel, and hereby files this. Motion to disqualify, recuse Judge Glanville from all further dealings in the above referenced case, and motion for mistrials, which was goaded by the improper conduct committed in concert by the court and prosecution. In support of this motion, Mr. Williams shows as follows. 1. Undersigned counsel represent Mr. Jeffrey Williams in the above referenced case. The jury trial of multiple accused persons commenced January 4th, 2023, before Fulton County Superior Court Judge Glanville. Well, technically it started November 28th. No, wait, January 4th. Yes, January 4th of last year. That is when jury selection started. So technically, all trial starts with jury selections. And that took 11 months before they were done with jury selection, which is, it's stupid. You could find a trial of this magnitude that was supposed to be 6 months long. You should be able to do that in a month tops. A month. So this trial should be ongoing, but the prosecution dragged it on, the judge dragged it on, and this trial expected to last at least through the end of the 2024 calendar year. Yeah, at least. On Monday, June 10th, 2024, within 5 days of the filing of this timely motion, this court, along with the prosecutors, engaged in an unlawful, improper ex parte meeting with, among other persons, a sworn witness, Kenneth Copeland, for whom an order of use immunity had been issued on Friday, June 7th, 2024. No notice of this ex parte meeting was provided to any attorney for any of the criminally accused in the case. In fact, the accused and their counsel were in the dark that this quote-unquote star chamber meeting occurred. Mr. Copeland had previously been called to testify on Friday, June 7th, 2024, asserted the Fifth Amendment privilege in open court in front of the jury and was held in contempt, and summarily incarcerated in such time as he agreed to testify pursuant to the grant of use immunity. Judge Glanville and the prosecutors essentially admitted, by silence and by statements in open court. What that means is when these allegations about the ex parte meeting occurred, they didn't deny it. And in some case, in some statements, Judge Glanville said, yes, it happened. That an ex parte meeting occurred on the morning of June 10th, 2024, only after undersigned counsel revealed, based upon information and belief, that this impermissible meeting occurred. Let's see here. Number 3. At the earliest opportunity on the afternoon of June 10th, 2024, the court was informed, based upon information and belief, that the ex parte meeting with the sworn witness Kenneth Copeland and the prosecution occurred earlier that day, that the witness had made factual admissions, as in, I'm gonna lie, and I'm the perpetrator of the ending of Nut. And the statements were made to the witness by the court and the prosecutors acting in concert about the amount of time Mr. Copeland could be held in custody on the contempt, which is more or less indefinitely. They threatened Mr. Copeland with keeping him in jail until the last trial of the last defendant in this so-called criminal enterprise, because there's 12 others that is not in this trial. that had their cases severed. And they are waiting for this trial to end. So we are talking about years, multiple years, not just 2 years, many years. And allegedly, Miss Hilton claimed, or no, not claimed, but the claim is that Miss Hilton offered Mr. Copeland immunity even if he lied on the stand. Which is Jesus Christ. Oh, thank you, Jim Cox, for gifting 10 memberships. Thank you so much. Let's see who it went to. It went to Cami 216. The Rune Lady. Camille Gordon, Kimberly M. Gidelk 34, YouTube. Kali, Ghost Lee, Miranda Gomez, Cat Silver. Everybody say thank you to Jim Cox. Thank you so much. Much appreciated. Thank you. And you now have access to all my members-only content, which is a lot. And my members-only content is not much about law. It's more about me, so we get to know each other. It is the farm, the renovations, my personal thoughts, all of that things, and stupid memes, and yeah. So a little bit more personal. Thank you again. Now, where were we? The court denied undersigned counsel's request for the transcript of the ex parte meeting and denied the timely motion for mistrial based upon the improper and illegal ex parte meeting, which violated Mr. Williams' constitutional and statutory rights, including the right to due process, a fair tribunal, ethical prosecutors, and the right to be present at every critical stage of the proceedings under the Georgia Constitution. Yeah, Mr. Copeland admitting to the ending of not, yeah, you could say that's a critical stage. Another critical stage is the prosecution offering him immunity even if he lied on the stand. That's kind of a big deal. I'm still checking. Court is still not. I'm waiting for the law and crime stream to get. And here is the first footnote. A transcript of the relevant proceedings on June 10th, 2024 has been ordered from the court reporter. A video recording of the entire June 10th, 2024 trial proceedings can be accessed online at, number 5. Uniform Superior Court Rule 4.1 and Georgia Code of Judicial Conduct 2.9 delineate rules governing ex parte communications. Uniform Superior Court Rule 4.1 generally prohibits ex parte communications. Quote, except as authorized by law or by rule, judges shall, not may, shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. End quote. Hey, Raven. Ex parte hearings are only authorized in the case of extraordinary matters such as temporary restraining orders and temporary injunctions. Quote, in other judicial hearings, both parties should be notified of the hearing with an opportunity of attending and voicing any objection that may be properly registered. And here are the cases he's citing. Georgia Code of Judicial Conduct 2.9. Assuring fair hearings and averting ex parte communication provides. A. Judges shall, here's that word again, not may, not maybe, not if you really want to, no, shall, accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or the lawyers concerning a pending proceeding or impending matter, subject to the following exceptions. Here are the exceptions. Where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits. Emergency. Yeah. Oh, it's emergency. He doesn't want to testify. He's pleading the fifth. That's not an emergency. It really isn't. And if it handles substantive matters, no, you're not allowed to, Judge. You really aren't. 1A, the judge reasonably believed that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. How about that? You don't have an ex parte meeting if you believe that a party will gain a procedure or a tactical advantage. Miss Hilton told Woody that he could lie on the stand, more or less. B, the judge make provision promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. The judge wanted to keep this a secret until after the trial. That was his goal. 2, judges may obtain the advice of a disinterested expert on the law applicable to a proceeding before the court if they gave notice to the parties of the person consulted and the substance of their advice and afford the parties reasonable opportunity to respond. Wood is no expert. Judges may consult with court staff and court official whose functions are to aid in carrying out adjudicative responsibilities or with other judges. Hi, Andrea, and everybody else who tuned in. We are still waiting for today's trial result. So I'm reading Attorney Steele's motion to disqualify. Motion to cheat the judge. Or with other judges. There was no other judge there. If there were, I would certainly hope they would say, Judge Glanville, no. To avoid receiving factual information that is not part of the record. Yeah, he should avoid receiving factual information. That ex parte hearing was all about factual information and does not abrogate the responsibility personally to decide the matter. 4, judges may, with the consent of the parties, confer separately with the parties or their lawyers in an effort to mediate or settle pending proceedings. He didn't look for any consent. Judges may initiate, permit, or consider ex parte communications when authorized by law to do so, such as when issuing temporary protective orders, arrest warrants or search warrants, or when serving on therapeutic problem-solving or accountability courts, including drug courts, mental health courts, and veterans courts. None of that apply here. 5. This court violated USCR 4.1 and Georgia Code of Judicial Conduct 2.9. The court has joined the process. The court has joined the prosecutor's team and is biased against Mr. Williams and favorable to the prosecutors, as objectively demonstrated on June 10th, 2024, as well as throughout the pendency of this case. I'm taking credit here. I know he doesn't watch my streams, but just in case, I will take full credit because I've been saying that for months, that Judge Glanville could as well sit at the prosecution's table because he is a part of the prosecution. Yes, he has been a judge for almost 30 years. Brigadier General in Afghanistan for the judicial thingies. Maybe he just is so convinced of his own superiority that he forgot the law. That law still applies. Number 6. The trial court rejected undersigned counsel's substantive request for information about the unlawful ex parte meeting, and the court denied undersigned counsel's motion for mistrial. Instead, the court stunningly demanded to know how undersigned counsel came into possession of the information about the ex parte meeting. Yeah, that was a fustercluck. Complete fustercluck. The prosecutor stunningly sat mute and permitted this injustice to occur, and for the court to attempt to intimidate undersigned counsel. I'm not especially stunned about the silence of the prosecutors. Why? Because they're corrupt. They don't care about justice. They don't care about due process. They don't care about the Constitution or the rule of law or the Bill of Rights. They care about winning and winning alone. Later, Love, a lawyer currently employed with the Fulton County District Attorney's Office and allegedly sacrifices baby lambs to Satan, argued that the ex parte hearing with witness Copeland was ethical, just and proper. The other prosecutors still remained mute. Yeah, I don't trust Adrian Love with anything that gets to ethical matters. Why? Because I have read the Shane Kendall case, the Shane Kendall lawsuit for a wrongful death. You find those streams and videos on my channel. She is really, really evil. 7. Undersigned counsel declined to join in the antics in ignoring rules and ethical provisions, and declined to provide information requested by the court, relying on the State Bar Rule of Professional Conduct 1.6, which states in pertinent part that A lawyer shall maintain in confidence all information gained in the professional relationship with a client, including information which the client has requested to be held inviolate, and the disclosure of which would be embarrassing or would likely be detrimental to the client unless the client gives informed consent, except for disclosures that are impliedly authorized in order to carry out the representation or required by the rules or other law or by order of the court. Now, that rule seems a bit vague, but there's a comment 5, and this is so when you make a rule, as in the Georgia State Bar, in order to have that rule applied correctly, they make comments in order to make things more clear. This is comment 5. The principle of confidentiality is given effect in 2 related bodies of law: the attorney-client privilege, which includes the work product doctrine in the law of evidence, and the rule of confidentiality established in professional ethics. Highlighted. The attorney-client privilege applies in judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. The rule of client-lawyer confidentiality applies in situations other than those where evidence is sought from the lawyer through compulsion of law, as in contempt and threatened with jail. Unless you tell me who gave you that information, you will be in jail. That is in direct violation of this rule. Rule 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. Whatever its source, as in from somebody in that ex parte meeting. A lawyer may not disclose such information except as authorized or required by the Georgia Rules of Professional Conduct or other law. If you remember the tantrum Judge Glanville threw, he never cited law. He only claimed that Mr. Steele's statutes and rules were wrong. That's not how it works. You have to lay a foundation for your decision. And he didn't. Still nothing from the courthouse. Maybe Judge Glanville yeeted to Mexico. No, he didn't. See also scope. The requirement of maintaining confidentiality of information gained in the professional relationship applies to government lawyers who may disagree with the client's policy goals. Emphasis added. Okay. Oh, yeah. Woody, Mr. Copeland, the lawyer he fired was not his main lawyer, so to speak. Bumpus was only there for the limited obligation of the contempt hearing. Her being in an ex parte meeting, I could bet good money, was not part of the deal Woody's lawyer made with her. She was thrown in involuntarily in this. Was she the person who told Mr. Steele? Maybe. I don't know. We don't know. I don't care. But Mr. Woody, Mr. Copeland did not fire his original lawyer, who, when he gets back, and this is quite interesting, the prosecutors knew his schedule. They knew he was going on vacation this week. Or last week. No, this week. Well, whatever. Well, they knew he was going on vacation last week. It was because he had a meeting in the summer of 2023 with the prosecution because he was representing Mr. Copeland. They knew. So I don't think it's a coincidence that they chose to put Woody on the stand the week they knew the lawyer was gone. Let's continue. The court ignored the ethical rules relied upon and continued to demand undersigned counsel to reveal the source of the information, claiming that the way the undersigned counsel obtained that information was somehow unlawful. Nope. And baselessly accused undersigned counsel of, on the record, of potentially acquiring the information through eavesdropping. That's a crime. And when the judge accused Mr. Steele of a crime, Fifth Amendment applies. All his rights came crashing down. And just, he doesn't have to say a thing. If he is accused of a crime, he has the right to remain silent. In response to the specious accusations and the impermissible demands of the court, undersigned counsel relied on the ethical mandates of Rule 1.6 and the Fifth Amendment, right to remain silent, and declined to provide the source of information which had been proffered. The court is so biased against undersigned counsel and or Mr. William, the court ignored all laws and pursued contempt penalties to attempt to intimidate undersigned counsel to violate the law and ethics in order to continue to help the prosecution convict Mr. Williams and all others. Yeah, Teresa, he tried to take that accusation back. No, you can't do that. You can't sit as a joke, as a judge, say stuff on the record, and then say, whoopsie, joke. No, you can't. The court issued a written order of contempt and incarceration for Brian Steele, imposing the maximum sentence of incarceration for 20 days. See Exhibit A. The Supreme Court... Now we have stream from the courthouse, but nothing is happening. So I will have that in the background. And when they start, I don't want to miss a minute of what's going to happen this morning, because Judge Glanville have been stewing for an entire night about what we are reading here. The Supreme Court of Georgia has granted a writ of certiorari to address the appeal of the contempt order and has granted undersigned counsel a supersedes bond. The writ of certiorari, Jesus. Look it up. It's easy. It basically means it's not the appeals court, it's us. You need it. The appeals court punted it to the Supreme Court, and the Supreme Court, within an hour of getting it, granted supersedes bond. And remember, Judge Glanville said he can't appeal. As it turns out, he can. How about that? How about that? The court violated the law by failing its duty to recuse from presiding over this contempt proceeding. In such proceedings where the announcement of punishment is delayed and where the contumacious conduct was directed toward the judge, or where the judge reacted to the conduct in such manner as to become involved in the controversy, the judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted by another judge. Yeah. You can't decide, did I do wrong, by yourself in this case. You can't. You have to give it to another judge. And Judge Glanville? No. Hello, Divansmore. Good to see you. In Schoolcraft, Appeals Court 2005. Here, the court involved itself in those proceedings by joining the prosecution team and conducting the ex parte meeting that violated Mr. Williams' rights. This created a conflict of interest for the court because its own unethical conduct is questioned and at the heart of this issue. The court then compounded its abuse of power by presiding over the very contempt hearing where its own rules violations prompted the controversy. The court should have recused and allowed the contempt proceedings to be handled by a separate court. Further, the prosecutors sat mute and permitted the court to attempt to interrogate and intimidate another member of the bar who reported a violation of law and also promoted the court's wrongful conduct by inserting that the ex parte meeting was proper. This is so wrong on so many levels. A chairman's view. Kelly Nash? Sure. I would love to link up and do something together. Good content. Really good content. So infamous Sylvia. Really good content. I mean, yeah. There are a handful of us who have been covering this trial for a very long time, and yay to us. Let's see. Still checking. Still nothing in court. The court denied Mr. Williams and undersigned counsel their due process rights, as undersigned counsel has a right to adequate notice and to be heard, to call witnesses at a hearing, and to be represented by counsel for the entirety of the contempt proceeding. And Mr. Williams had the right to learn of all facts and circumstances of this critical stage of the proceeding that occurred in his absence, ex parte. 14. The court abused its authority by holding undersigned counsel in contempt for refusing to divulge privileged information and for protecting Mr. Williams' constitutional rights to due process, right to a fair tribunal, right to a fair trial, right to be present, and effective assistance of counsel. This court's refusal to acknowledge these rights and protections has created an unfair tribunal based upon bias against Mr. Williams and or his counsel and favoritism to the prosecutors. I've been yelling from the rooftop for months about this judge's bias. Finally, I see all the big channels, all the huge law channels. Now the finally acknowledgement. Well, not me, but for the situation at hand. Because this is not, oh, what did he do? This must be a one-off thing. No. If you've been around from the beginning of this trial, or even from the beginning of this case, you've seen it. You can't avoid to see the bias, the unfairness, the corruption. You just can't avoid seeing it if you follow this case. 15. Motion to disqualify recused Judge Glanville is timely filed as Uniform Superior Court Rule 25.1 mandates that the time for filing a motion to recuse shall be not later than 5 days after the affiant first learned of the grounds for disqualifications. Now, he turned this over yesterday, Monday. Well, that's 7 days, Nick. No, 5 court days, as in Monday to Tuesday, Tuesday to Wednesday, Wednesday to Thursday, Thursday to Friday, Friday to Monday. So today, timely. After the affiant first learned of the grounds for disqualifications, the Honorable Supreme Court of Georgia has taught that a motion to recuse is timely filed under this rule if it is filed within 5 days after the affiant first learned of the alleged grounds for disqualification, excluding salaries and solace. Yeah, okay, yeah. I should have just kept reading. It's right there. See Mayor and Alderman of the City of Savannah v. Batson Cook County. A lot of numbers and words. Thus, this motion to disqualify recuse is timely filed, as the reason for this disqualification recusal was first learned on Monday, June 10th, 2024. See Exhibit B, joint affidavit attached hereto. The record also reveals numerous instances during trial when the judge's behavior appears to have been biased against Mr. Williams' counsel and partial in favor of the state. See Milhouse v. State, all that. Contentions that the trial judge's derogatory or prejudicial statements and demeanor will be considered as so long as a reviewable record have been completed. One method of creating such a record is to obtain testimony from witnesses who were in the courtroom at the time of the incident in question. As in, when the judge called Mr. Shard, Mr. Steele, unprofessional in front of the jury. Now, remember how many times the state, the prosecutor has lied to Judge Glanville's face, and he does nothing. Mr. Steele and Mr. Shard apply correct rules in order to question some rulings and try to get evidence out, and the judge gets mad at them. It's deeply, deeply unfair. Hi, Ghost. And Jeannie, Robert, and yeah, there's a bunch of you here. Have you hit the like button yet? Hit the like button. You know you should. The record reveals other instances too, when the trial court wrongly berated counsel in front of the jury. I should just keep reading. After a number of such incidents, Mr. Williams' counsel, out of the jury's presence, moved for the trial judge's recusal and sought a mistrial on grounds that the judge had shown a lack of objectivity, had displayed bias against Mr. Williams and his counsel, and had assisted the prosecutors in making their case before the jury. Judges have an ethical duty to disqualify themselves from any matter in which they have a personal bias or prejudice concerning a party or an attorney appearing before them. In this regard, a trial judge, quote, shall, that's that word again, not may, not if you want to, but you really don't need to, shall avoid all impropriety and appearance of impropriety. Appearance of impropriety is vague, but it means you shouldn't even look bad when you do your rulings. The Code of Judicial Conduct provides that, quote, judges should disqualify themselves in a proceeding in which their impartiality might reasonably be questioned, including but not limited to instances where, ... the judge has personal bias or prejudice concerning a party or a party's lawyer. Within the context of this requirement, the word should means shall. I'm hearing. Okay. I will continue to read later.
Williams, Mr. Steele, Mr. Adams, and Mr. Monsbach, good morning, and Ms. Haltwinger, good morning.
This is the
All right.
roll call.
Okay, Mr. Kendrick and Ms. Hingerty. How's Mr. Weinstein? Okay, all right, okay. All right. Mr. Huey and Mr. Matthews, Jr. and Senior, good morning, gentlemen. All right, Mr. Nichols and Mr. Harvey and Ms. Westmoreland, good morning. And Mr. Ryan and Ms. D. Williams, good morning.
Good morning.
All right. Mr. Atkins and Ms. Hilton and Ms. Knight, good morning. Good morning. All right. I missed anybody?
Miss Lovinson's there yet?
Okay, all right.
Interesting. Is she leaving, defending their
Okay,
conduct to Miss Hilton? Oh,
first order of business the court needs to take up this morning. I have two motions to recuse, one filed by defendant Jeffrey Williams that was filed yesterday and handed to the court at the end of the business day. Another one has been filed under the same indictment, just indictment 22 SC 183572. And I want to say that motion to recuse has been filed on behalf of Miss Kayla Bumpus. Can I get the lawyers or the principal lawyer for that particular case to identify themselves for purpose of the record?
Judge, good morning, Gabe Banks.
Good morning, Mr. Banks.
okay. So both Mr. Steele and Mr. Williams and Miss Bumpus is calling for him to recuse himself because she's been called to this hearing on the 25th and she don't want to go there. I understand why.
Her legal team is also here. Mr. Collins, this morning. And,
Legal team.
All right, good morning, counsels. Okay, as it pertains to your motion, Mr. Banks, and on behalf of everyone that is here, I'm going to just take up the issue of the recusal. I'm going to defer the issue of the motion to quash at this point in time, okay? So I'm not going to take up anything. I can't do it anyways because the rules require me to go ahead and deal with the motion to recuse to begin with. So I've ceased any other business, and that's why I had Mr. Chamberlain reach out to you last night and counsels for you all to be here this morning so I could take this up. Your motion actually was filed last Friday at 10:40 p.m. It didn't appear in the system, however, as sometimes Odyssey happens, until sometime on Monday evening. So when I started to read Mr. Steele's affidavit last night, we were put on notice that there was possibly another affidavit out there and another motion. So that's why we had to call you, okay? So that's how we got here with this. Or else, did you all attempt to send me independently a copy of that, or?
we did not, Judge.
Okay, no harm, no foul, no. So no, I just wanted to know if you had attempted to do so, because we would have certainly, had we known that, pulled you in on Monday morning, which would have been the closest time that I could have heard your particular motion. So just from a time aspect, I just wanted to account for that. Taking a look at this applies to both motions that have been filed to recuse the court or disqualify the court. Recusal by a Superior Court judge is governed by Uniform Superior Court Rule 25, etc. Rule 25.1 provides that all motions to recuse and disqualify a judge presiding a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavits, which shall fully assert the facts upon which the motion is founded, filing and presentation to the judge shall not be later than 5 days after the affiant first learned of the alleged grounds for the disqualification, and not later than 10 days prior to a hearing or trial, which is the subject of the recusal or disqualification, unless good cause be shown for the failure to meet such time requirements. And that is cited in Georgia Uniform Superior Court Rule 25.1. So I'm applying that to both sets of motions to recuse. And applying this rule, Georgia courts have held that when a motion to recuse is filed, the trial judge shall immediately, 1, determine the timeliness of the motion, 2, the legal sufficiency of the affidavit, and 3, the legal sufficiency of the grounds, and has no power to do anything else. And that is Robinson versus the state, 332 Georgia Appeals at 242-41. The 3 threshold determinations that the trial judge must make in regard to a motion to recuse are whether it's timely filed, whether the affidavit made in support is legally sufficient, and whether some or all the facts set forth in the affidavit are true, recusal would be warranted. And that is Dacker versus the state, 300 Georgia, 74-77, 2016. The judge finds any 3 of the conditions have been met. No, I'm sorry, take that back, strike that. If the judge finds that all 3 conditions have been met, he must refer the motion to another judge to hear the motion. But if any one of the conditions is not met, there is no error in denying the motion. And motions to recuse are viewed and considered by the appellate court for abuse of discretion. Accordingly, the court is going to address each one of the factors as it pertains to both Mr. Steele's motion and, for shortness, Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was in fact filed on this past Monday.
Which is 5 days, exactly.
Which would have been the 17th of June. I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed, as it was filed on the filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit, that means, was it sworn? Was it sworn before a notary? Is in proper form? I find Mr. Williams and Ms. Bumpus's motions to be, or I should say affidavits, to be in proper form. The third thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion. And
yes, Judge.
And here's where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only 3 things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time, let you all take it up. No, I won't grant a motion for a certificate for immediate review. And that's where we are at this point in time. Anything else, Mr. Banks?
If I could just briefly be heard, Judge.
Sure.
Please. And I'm not trying to, I understand the court's ruling and we'll proceed as we see fit. I do take issue with the court's characterization about the legal insufficiency of the affidavits.
Well, that's why when it was reviewed on appeal,
Sure.
it can certainly be, I mean, the appellate court will review my ruling for, for abuse of discretion.
Certainly
Okay.
understand that, Judge. And in stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding, not the underlying criminal case in which Your Honor is presiding. And so we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding. And so because you were a witness.
I don't believe you. I'm not going to get into any argument, but I can't. So that's your assertion at this point in time. And like I said, when that is taken up, I'll consider it. I also remember, I still need to rule on the issue of.
Judge Glanville, you lying sack of shit. You're lying and you know you're lying. You were a witness in that ex parte hearing because you agreed to the prosecution holding it. You're a witness. You can't hold that contempt hearing. The law and statute is crystal clear. But the Judge Glanville doesn't care. He will cling to this trial until the Georgia Supreme Court drags him out of that courtroom. He stopped caring. He will deny everything, defer it forward to the appeals court or whatever's. This is unheard of.
The motion to quash. So I may, depending upon what I decide to do at that point in time,
Sure.
Other things may be ripe. Okay.
Do you want to hear about the motion to quash, or you want to take?
No, not yet, sir. I'm going to take up the motion to quash after I finish. We finish the direct of the current witness.
Okay.
And to other issues that have been raised, as I've told some of the other lawyers here,
next week,
there is a transcript of what occurred in the ex parte matter. I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and/or Brady. And for that, and I will do that. And then if
did you hear that? This judge says that he will review the transcript and he will decide what is Brady or not Brady. He who just this lying sack of shit.
that pertained, or if that issue affects you, then certainly that may be something that at the appropriate time you'll be able to have a look at.
Well, I appreciate the court's time. We would certainly rely upon our brief and our motion, and that's a part of the record.
Okay. All right. But I will reach out. The court will reach out to you on two things. One, the ability to take a look at the ex parte transcript and review it for the appropriate parts that the court will authorize. And then also for the, I'll re-notice you because I know
that transcript will have the same fate as Ms. Gautier's reports. Shredded, buried, deleted. Anything to avoid accountability for the crimes this judge committed.
that it's supposed to be done this Tuesday, but I doubt that we'll probably have it this coming Tuesday.
If I just may say, again, Judge, I know I've already said it as it concerns the issue about you being a witness to the proceeding.
This transcript won't be done until after the 25th of that hearing. Isn't that convenient?
We don't believe that that's a bare allegation. We believe that would be an established fact at the hearing. We also,
But I can't take it. It's not something that I can argue with you at this point in time.
and I'm not trying to argue.
No, sir. You are an advocate for your client. Sure. That's the only thing I can say, but I'm not going to take up that issue right now. It's part and parcel. You made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I've made my ruling. You've said what you need to say in terms of what your thoughts are. I'm going to reduce it to an order, and you can take what you want to after that. Okay.
All right. Thank you.
All right. Thank you, sir. All right. Mr. Steele, similarly, I'll reduce what I have mentioned to in an order, and you will be able to take it up as you see fit. I'm not going to grant a motion to a certificate of immediate review. Anything else?
Judge Glanville will do anything to postpone another judge to ever take charge or even hearing about his misconduct. Now it's just postponing. Robert, yeah, that transcript will be sanitized. Here's the issue. Bumpus is a witness. If that transcript does not reflect what was said, we will hear about it. But then it will be a judge against an accused lawyer. So this is so corrupt. Mr. Steele.
I have read Baptiste versus State. I've read all the cases that I believe are applicable. I'm, best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting ex parte with the court and others and the prosecutor and a witness, and specifically they wrote in a pleading and under Parrish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022. The lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just asked you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I asked the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand
I'm
how.
not gonna, Mr. Steele, I can't argue with you about anything such as, I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're gonna have to put those in some other pleading. But at this point, Miss Weaver is gonna prepare the record. She does that. And like I said earlier, the record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
Interesting. It's Rebecca's story. Kayla Bumpus is friends with Miss Hilton and sorority sisters. She also was assistant DA for Fulton County through 2017. Yeah, that can create quite an interesting conflict because Miss Hilton works alongside Miss Love. But Miss Hilton, Kayla Bumpus, that's sorority sisters. Who? Thank you for the super chat. Much appreciated. Thank you so much. Yeah, this is... Yeah, the judge is lying. He's a liar. He claims he has read the cases, and then he should know that the cases supports the motions to for him to recuse himself. But he is not having it. He is not having it. He will cling to that chair until he's dragged out of this courtroom. He will do anything. And he already does it illegally to make sure that this will render a conviction and that the defendants will remain in jail. And that Miss Bumpus, in that hearing on the 25th, that she will be punished. He will not stop until the Supreme Court says, get out. I think the judge is eating breath mints or something because he has a cold. Now I have Miss Bumpus, I think. Yep, I have her motion to quash. To show cause, a motion to recuse this court. So I have it here. Let's see if they are going to break.
Okay. All right. Let's turn now to the statements or interviews from January.
That finishes our business today, man.
You don't want to stick around? Okay. Well, okay. Thank you, Mr. Banks. At all. Okay. All right. Okay. Yes, you may be excused, sir.
And now the judge will pretend as if nothing happened. You absolute forkwad. Thank you. Beautiful decisions for your super sticker. Hug. It's a hug thingy. Thank you. And it's your first super on the live stream.
All right, Ms. Hilton.
Thank you. Thank you so much for your Australian dollars. Thank you. I'm very honored. I'm deeply honored. Thank you so much. Thank you. Thank you. Thank you so much. Thank you to everybody for gifted memberships, super stickers, super chats. You are... That is what keeps this channel afloat. So thank you so much. Now let's listen to Judge Glanville pretending as nothing happened.
And counsels.
Pretending he's not a corrupt...
What
a bitch.
matters you have to take up from the interview
He's a corrupt son of a bitch that he shouldn't be allowed into a courtroom until he is a defendant.
from the the January 28th, 2015 interview?
Your Honor, last night we sent over both the February 21st and January 28th redactions. We sent the February 21st one around 7 p.m. and then the January 28th probably around 11:30. We have not heard from defense counsel yet, so I'm not sure if they reviewed them and if they have.
Thank you. Thank you so much. And
Any additions or disagreement. So we were just waiting for defense counsel to let us know their position.
Okay. Counsels for defendants, have you identified, since now the state has sent you parts from the 28th January interview that you wish for us to talk about?
I mean, the standard is appearance of impropriety, being an asshole. Or the appearance. The standard is the appearance. And he claims there is no legal basis for that, which is, July 77, straight criminal behavior. Straight up criminal behavior from this judge. In my opinion, Fannie Willis mislove this judge, 2 or more people colluding to commit crimes. That's a criminal enterprise. That's RICO.
Mr. Sharp?
Good morning, Your Honor. I have not had a chance to digest their proposed redactions. I'm happy to talk to them about it. I've been working feverishly on getting together the redactions that we believe are warranted. Again, I'd be happy to talk to the state about that. I'd also be happy to go through them one by one with the court, however is favored. But I can't say at this moment that we've cross-referenced the 2 lists.
Okay, all right, so that's what we're supposed to do this morning, though. So does anybody else have flagged or wish to be heard on the interview for January the 28th? Sure. We're going to cover them independently. Like the January 28th, we'll cover the February 21st, and then we'll cover the June the 10th interview, and then potentially the jail calls.
I believe that myself and Attorney Steele may both have lists. I don't.
May have what? Sorry, I'm sorry.
Lists.
Okay.
But we're representing different individuals, so the list may vary a little bit. So you may be getting some suggestions from this chair, some suggestions from that chair, and then some suggestions from the state.
I understand.
Yeah. Okay. Your Honor, may we have 15 minutes to just talk to the state about their list?
Yeah. Does anybody else have any statements that they've identified from the January 28th or February 21st or June 10th, other than Mr. Steele or Mr. Sharp, that they want to bring up?
Yeah.
All right. Okay. All right, then I'll.
And the disturbing part here is that the defense knows that this judge now have given himself carte blanche, free rein until the end of this trial to be corrupt. But they still have to play by the rule book. They have to. And they have no choice than to sit there, look at Judge Glanville and the prosecutors, knowing they are cheating, knowing they are colluding, knowing they are corrupt, and they can't do anything else about it than to object and keep filing motions. That's all they can do, because the judge has clearly, to everybody in courtroom, outside of courtroom, to you, stated he will be there until the Supreme Court drags him out.
give you all 15 minutes and you can come back and we can just begin with the 28th of January interviews. Okay. All right.
All right. They are now on a break. So let's keep reading what we started before he started lying to us. Mr. Steele's motion of recusal of the judge. Yeah. Here it is. The thing we just talked about. The Code of Judicial Conduct provides that, quote, judges should disqualify themselves in the proceeding in which their impartiality might reasonably be questioned, including but not limited to instances where the judge has a personal bias or prejudice concerning a party or a party's lawyer. Within the context of this requirement, should means shall. Within the context of this requirement, the Supreme Court is mindful of the extraordinary pressures attending a criminal trial of this magnitude. On one hand, defense counsel is obligated to vigorously defend his client against all charges brought by the state. Likewise, prosecutors must effectively and ethically present the state's case to a jury. This prosecution does neither. We are over 7 months into this trial. A trial that should be in total 6 months. And we're not even halfway through the state's case in chief. That's not effectively. And ethically, ex parte meeting with a sworn-in witness to collude with the judge to make him testify and even give him immunity, even if he lies on the stand. At the same time, the trial judge is charged with ensuring that the rules of evidence and procedure are followed, which he don't, and that the proceedings are both orderly, ethical, and fair, which it isn't in this trial. When these several interests come together in the courtroom during trial, disagreements between the bench and bar are to be expected. Sorry. The instances discussed above and in the attached Exhibit B, joint affidavit, however, represent more than mere friction between zealous counsel and diligent jurist. The judge's conduct, as discussed above and herein, created the impression that he harbored an inclination to be biased against Mr. Williams and his counsel and partial toward the prosecution. That's an understatement, in my opinion. Higher courts need not decide whether such bias and impartiality actually existed, because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned, including instances where the judge's behavior should indicate that he has personal bias or prejudice concerning a party or a party's lawyer. As explained, the trial judge in this case participated in ex parte communications with the prosecutor in which he assisted the state to influence a witness to testify against Mr. Williams. These actions certainly raised reasonable questions concerning the judge's partiality and bias. Because the trial judge's impartiality is reasonably questionable, it is error to deny Mr. Williams' motion for recusal. And here's Johnson v. State. Our highest court has set forth at least 3 circumstances in which recusal of a court is necessary on the ground of mere appearance of bias, even in the absence of evidence of actual bias. Mr. Williams does not waive that actual bias have been objectively shown throughout trial, as well as on June 10th, but for simplicity, the appearance of bias is also met. 2 of these circumstances arise in the case at bar. The third circumstance in which recusal is required on the ground of mere appearance of bias, absent evidence of actual bias, is when a judge has a direct, personal, substantial, pecuniary interest in reaching a conclusion against a litigant, as in telling Woody, if you don't testify as the prosecution wants you to, I'm going to keep holding you in contempt indefinitely. Based upon a motion of belief, this first, where mere appearance of bias requires the recusal of a judge when the judge becomes embroiled in the controversy with one of the litigants. Some relationship between the judge and the lawyer was such as due process required recusal of the judge. Yeah, due process, as in don't hold ex parte meetings. Exhibit B. The court favors the prosecution and is attempted to sabotage the defense by helping the prosecution, threatening a witness to testify the way the prosecution wants. Georgia courts have followed this demand for recusal when the judge becomes embroiled in the controversy. In Berger, due process requires that the trial judge cannot be both the prosecutor as well as the judge in our judicial system and thus must be recused. And this is another case in Schoolcraft. Second, due process requires recusal of the judge when the judge takes a role in the accusatory process. In Murchison, Supra, or highest court explained that the Constitution prohibits a scenario where the judge orders witnesses to appear before him/her in order for the judge to gather facts to determine whether contempt proceedings should occur, and then the same judge presides over the contempt trial. Yeah, it's right there. And the judge doesn't care. He doesn't care. This because such a judge grand jury arrangement caused the judge to become part of the accusatory process, and thus this judge must be recused from further dealings on the case. Here, Judge Glanville has ordered Mr. Copeland's lawyer and others to appear to give information on a contempt proceeding. Same is against the law. Importantly, a trial judge has the duty to recuse itself sua sponte, voluntarily, more or less, from any proceedings in which the judge's impartiality might reasonably be questioned, including instances where the judge has a personal bias or prejudice concerning a party. The phrase, quote, impartiality might reasonably be questioned, end quote, means the existence of an objectively reasonable perception of lack of impartiality by the judge, held by a fair-minded and impartial person based upon objective fact or reasonable inference. These states. To warrant recusal, the alleged bias must be of such a nature and intensity to prevent the complaining party from obtaining a trial uninfluenced by the judge's prejudgment. To warrant disqualification of the trial judge, the affidavit in support of the motion seeking same must support the charge of a bent of mind that may prevent or impede the impartiality of the judge. The state v. Robertson. Mr. William met his mark, C of Exhibit B. Recusal is objectively required when the judge serves both as the accuser and the adjudicator in a case. Williams v. Pennsylvania. 23. Jesus Christ, how much more is it? Well, the court is on break. 15 minutes, it's at least half an hour. It usually is. Thank you for sticking around. Hit the like button, subscribe. You all know the things. In the case at bar, the court met ex parte with prosecutors and sworn witness Copeland and never intended to reveal that ex parte meeting occurred to Mr. Williams and or his counsel or to anyone for that matter. Exactly. The court has become part of the executive branch prosecuting Mr. Williams. I've said this for months, folks. Months. Judge Glanville could as well sit at the prosecution's table. That is how he acts in this file. Moreover, the prosecutors have abandoned and violated their ethical duties by engaging in this ex parte meeting and sitting silent while the court held undersigned counsel in contempt and failed to reveal any Brady evidence from the meeting, including the fact that this meeting occurred. Not revealing this meeting actually occurred is, in my opinion, in itself a Brady violation. Including the fact that this meeting occurred. The court and the prosecutors should not be working together, but they are, teaming up to gain an unlawful advantage over Mr. Williams. Mr. Williams' trial is constitutionally fractured, unfair, and lacks all constitutional, statutory, and ethical safeguards and protections of due process of law. Yeah, and that is because Judge Glanville probably realizes he done effed up, but he's too invested, and he will never let go of this trial voluntarily. The court is biased against the accused and his counsel. The affidavit. No intellectually honest person could believe that coercing witness Copeland to testify in a quote star chamber and quote setting meets constitutional muster. This court has failed to follow the lawful path. Instead, the court has unlawfully become the prosecutor, biased, partial, potential sentencer, and thus must be removed from this case in total instanter. Immediately. I'm not following the chat at the moment. If you have a questions that you really want answered, put the big question mark. Then I will see it easier. The big red question mark. Then I will see it easier. For the motion to disqualify, recuse, it is the duty of the judge to pass only on the legal sufficiency of the facts alleged and to ask whether these facts support a charge of bias or prejudice. Neither the truth of the allegations nor the good faith of the pleader may be questioned. Oh, hello! I got raided from Captain Williams. Hey! Hey, yo! Good to see you all here. Hit the like button, subscribe if you haven't. Can a moderator put Cat Not Williams link in the chat so that my viewers go subscribe to her as well? Please, thank you. Hi, we have been listening. We saw the Fuster Clock. That was Judge Glanville's criminal conduct in the courtroom, where he denied both motions without any basis, in my opinion. He didn't give basis. He just said, "Oh, I don't think it's sufficient," which is ridiculous, absolutely horribly ridiculous. Before that happened, we started reading from Mr. Steele's motion to yeet the judge. And if they are not back from the break after we are done with this, I will read Bumpa's motion to quash and motion to recuse. Oh, sorry. So let's continue and welcome. Neither the truth of the allegations nor the good faith of the pleader may be questioned, regardless of the judge's personal knowledge to the controversy. The test is whether, assuming the truth of the facts alleged in the attached affidavit, a reasonable person would conclude bias exists on the part of the judge. Fourthly state, Adams. So they have a bunch of. They have so many statutes and so much case law. It's ridiculous. This court conduct raises a strong finding that it has become personally embroiled in the case. It is clear, even to a casual observer, that this court's involvement in this controversy requires this court to be disqualified, recused, removed from all further proceedings in the above reference case. Instanter and another judge who will duly exercise the powers of the judicial branch with partiality, clarity, and fairness must be appointed to the case. Yeah. And hello, everybody. I'm Nick. I'm the Nick of LawTube without powder on his nose. But I do labor law. I have a law degree. I have been practicing for over 30 years. So I do have some understanding about law, due process, and everything, even though I'm not working in the United States. But what can I say? When I'm wrong, the chat will tell me. They will always tell me, So that is the great cooperation between me and the chat here, which it's so fun. Thank you for being here. Where were we? Fairness must be appointed to this case. It is critical to the functioning of our courts that the public believe in the absolute integrity and impartiality of its judges, and judicial recusal serves as a linchpin for the underlying proportion that the court will be fair and impartial. Yeah, but this is Fulton County, and it seems like both Danny Willis and this judge will be re-elected. Now, this judge is already re-elected, uncontested. So for the next 4 years, he's not going anywhere unless the Supreme Court drags him out of the courtroom. The Georgia Code of Judicial Conduct, Rule 211A, mandates that the judge must disqualify himself in any proceeding in which the judge's impartiality must be reasonably questioned. The creaking is my chair. I'm a big dude, and sometimes the chairs I buy don't hold big man. Sorry. With reasonable question of which the judge has a personal bias or prejudice concerning a party or a court lawyer. This motion to disqualify, recuse Judge Glanville, accompanied by the attached affidavit, mandates that Judge Glanville shall immediately cease to act upon any matters involved in State of Georgia v. Jeffrey Williams et al. Supra, shall immediately determine the timeliness of this motion and legal sufficiency of the attached affidavits, and assuming that any and or all facts alleged in the affidavit to be true, whether recusal will be warranted. Now, what the judge leaned on was this: legal sufficiency. He didn't quote any statute, no Georgia bar rules, no nothing. He just said, it is my opinion that legal sufficiency isn't met, which is astoundingly bad. If it's found that this motion is timely filed, the affidavit is legally sufficient, and that recusal will be authorized if some or all of the facts set forth in the affidavit is true, which it does. Judge Glanville must cease from any further contact with the case, and another judge shall be assigned to hear this motion to disqualify recuse Judge Glanville. Judge Glanville cannot in any way oppose this motion. See Monday, the Magnolia Advanced Material Inc. Georgia case. But he did, anyways, because Judge Glanville isn't going anywhere. He will glue himself to that chair. He will make more. He will see this trial to its end, unless Georgia Supreme Court drags him out of there. The attached affidavit clearly set forth the facts and reasons for the belief that bias and/or prejudice exist on the part of Judge Glanville. The allegations is attached in the attached affidavit are not just their conclusions and opinions, but are facts. Georgia Code of Judicial Conduct Rule 2.11 mandates that Judge Glanville must disqualify recuse himself from this case in stanter immediately. In the alternative, another judge must. But now they are reiterating, because of different rules, that what they have said earlier, which they have to, more or less. Every piece of every bullet point, they must reiterate what they believe this will show. So now it's getting a bit repetitive. But here, furthermore, Judge Glanville's potential bias is of such nature and intensity to prevent Judge Glanville from being influenced by his prejudgment. Furthermore, Judge Glanville's potential bias is of such a nature and intensity to prevent Judge Glanville from being uninfluenced by his prejudgment. As in, he's so far gone, he might not see his conduct is illegal, unethical, and rule breaking. Judge Glanville's conduct gives fair support to a charge of a bent of mind that may prevent or impede the impartiality of justice if Judge Glanville is not disqualified from this case. And they have all these cases. Further, this indictment must be dismissed, a mistrial granted, but based upon the court's and prosecution's continued misconduct, as shown in Exhibit B attached here to, the constitutionally required fair trial occurring before a fair tribunal with ethical prosecutors has been violated. This includes, but is not limited to, witness intimidation, And here they cite a lot of cases. Judge Glanville, lawyers for the state, Love and Hilton, will be called as witnesses at trial for the jury to understand this ex parte meeting and determine demeanor and credibility. Yeah, they want a jury trial on this. Well, that's interesting. Additionally, Mr. Williams, what is that? What it says? I need to read that. Yeah. Mr. Williams demands all ex parte meetings to be disclosed in order to properly reveal the full extent of all violations of law and ethics. Yeah. The theory out there is this is not the first ex parte meeting in this trial. This is the first they were discovered. Metalcore asked Nick, do you think that the Georgia Supreme Court will step in? I hope so. But here's the thing, Judge Glanville won't allow it. He won't allow the certificate that allows the defense to move forward with the appeals. What they need is a writ of animus. They need a writ which supersedes the Judge Glanville's power to intervene. And they need to address the appeals court, who will vote it to the Georgia Supreme Court. Somehow there will be a way to work around this. Again, lawyers for the state, Love and Hilton and Judge Glanville are necessary witnesses at this hearing and trial to determine the correctness of the motion for mistrial goaded by conduct of these parties and judge. Wherefore, based upon the above and the attached affidavit, if Judge Glanville does not immediately recuse from any and all further dealings on this case, this motion must be set down before another judge to determine why Judge Glanville can continue to serve as judge in this case, which Judge Glanville will not allow. Further, a mistrial must be granted upon this judicial and prosecution violations of law and ethics. Respectfully submitted. And here are the different Exhibit A, Exhibit B. I read that in an earlier stream, so I will not go through that again. Let's see here, they are still not back. So let's go to Bumpus. Motion to quash order to show cause. Yeah, that's the hearing on the 25th, where Judge Glanville wants to throw Bumpus in jail for allegedly telling the defense what was going on. Oof. Comes now! That's what. Attorney Kayla Bumpus is under some counsel and files this motion to quash the court's order to show cause filed on June 11, 2024, or in the alternative moves this court to transfer this action to another judge or recuse itself as required by law. In support thereof, Attorney Bumpus shows the following. The recitation of the facts. Now we get to hear what might have been going on in that ex parte meeting. Time to pay attention. On Friday, June 7th, 2024, during the trial, the state immunized Kevin Copeland and called him as a witness. Copeland refused to testify. The court placed Copeland in custody over the weekend for his refusal and adjourned until Monday. At this point, Copeland was still sworn as a witness and had not been dismissed. On Monday, June 10th at 8:30 a.m., Copeland and his lawyer, Attorney Kayla Bumpus, were escorted to this court's chambers and conducted an ex parte meeting regarding whether Copeland would testify. I haven't read this before, so you know, this is new for me. I haven't read this. I don't actually know what the allegations or what she claims here. I have no idea. I'm just reading. I'm finding out as you find out. Those present for the substantive portion of this ex parte meeting were Chief Judge Glanville, Copeland, Attorney Bumpus, Assistant District Attorneys Adrian Love and Simone Hilton, members of the court, security staff and deputies. That's a bunch of witnesses. 2 investigators from the District Attorney's Office and a court reporter. In chambers, this court asked Copeland whether he was prepared to testify. Copeland announced that he planned to again invoke his Fifth Amendment privilege on the stand. A conversation among the parties ensued regarding Copeland's understanding of immunity, how Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. So Mr. Steele was right. They discussed ex parte critical things that was happening in the trial, which makes it their business. They should know this. How Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. Once Copeland learned that he could be held indefinitely by the court if he refused to testify, not just 2 years as he initially believed, Copeland decided that he would testify. That is coercion from the court on this witness. That is coercion. Textbook coercion. Copeland added that his testimony would be a lie. The meeting ended and the parties went to the courtroom. Now, she does not claim that Ms. Hilton gave immunity for lying. It might show up later. I don't know. This ex parte meeting was not placed on the seal. Ta-da! There was no protective order that directed that disclosure of these ex parte communications was prohibited. How about that? No attorney-client privilege existed. Clearly, as true prosecutors, investigators, a judge, a court reporter, and various court staff were also present. Yes, attorney-client privilege only applies in private conversation between the attorney and the client, which extends to work product, which extends to all information you might find out as you represent the client, whatever its source. The court never stated, ruled, or inferred that the meeting was meant to be confidential. Further, the content of this meeting was not secret, protected, or in any way privileged information. Let's see footnote 2. If there was any privilege, such as a attorney-client or work product, the privilege would be destroyed with all other parties present, particularly the court reporter. Yeah, she wrote it down. There's a transcript which annihilates any attorney-client privilege. It is unclear why any person present would have understood that the content of the meeting could not be shared with other attorneys of record in the case who are also with fellow officers of the court. Later that same day, defense counsel, Attorney Brian Steele, addressed this court to make a record of his due process concern regarding ex parte meeting. The content of said meeting would not just be non-confidential, but would usually be given to the defense under Giglio and Brady. Yeah. These are, in legal matters, ancient statutes. During Attorney Steele's attempt to put his due process concern on the record, this court began to focus on the identity of the source who, quote, leaked, unquote, the meeting to the defense counsel. The court ordered Attorney Steele to provide the name of the person who divulged the existence and content of the ex parte meeting. Attorney Steele refused. A brief hearing followed, and what initially appeared to be a classic civil contempt action, the attorney could purge himself of contempt if he provided information to the judge, became a criminal contempt action. The court found Attorney Steele in direct criminal contempt. This court sentenced Attorney Steele to the maximum time allowed, which was 20 days to serve in full contempt area. On June 11, 2024, this court entered a show cause order directing all individuals that were present for the ex parte conversation that took place in the court's chambers on the morning of June 10, specifically Copeland, his attorney, Attorney Bumpus, quote, and all representatives of the state and court security personnel that were in attendance, end quote. To show cause, quote, why one or more of them should not be held in contempt for disclosing information from the ex parte conversation to the members of the defense counsel, end quote. This is highly illegal. This should be an emergency meeting for the Georgia State Bar, where they call the prosecutors, and the judge to defend their position, in my opinion. No specific names were included in the order other than Copeland and Attorney Bumpers. Arguments. The court seeks to hold in contempt the person that leaked the ex parte meeting to defense counsel. Thus, the contempt hearing will be about who informed defense counsel whether to find that person guilty of criminal contempt, and if contempt is found, the appropriate punishment. The procedures that the trial court must follow to hold a person in contempt depends upon whether the acts alleged to constitute the contempt were committed in court, direct contempt, or committed out of court, indirect contempt. Here is the thing. An alleged contumacious act may only be said to have occurred in the presence of the court, warranting summary contempt proceeding if the act was committed in open court, which it wasn't. On the other hand, where the alleged contumacious acts are committed outside of the court's presence, the considerations justifying expedited proceedings do not pertain. Thus, summary adjudication of indirect contempt is prohibited. The due process requires that a person who is tried for indirect criminal contempt is entitled to more normal adversary procedures. Among other things, he or she must be advised of charges, have a reasonable opportunity to respond to them, and be permitted the assistance of counsel and the right to call witnesses. And the witnesses in that hearing that Judge Glanville have called is himself. Him. He's in the center of this. But no, he's going to be the judge in that proceeding. Yeah, and then quote this Adams' emphasis in original, the quote, disclosing information from the ex parte conversation to members of the defense counsel, end quote, occurred not in open court or in chambers, but at a time and location that defense counsel were notified of the ex parte meeting. So the direct contempt involves contemptuous conduct in the presence of the court, which generally results in immediate punishment. Here, the need for punishment is clearly not immediate, as demonstrated by the show cause order being set 2 weeks out from the order. So direct contempt should be out. But this is Judge Glanville's show. He can do whatever he wants until the Georgia Supreme Court drags him out of there. Forms of contempt are further divided into criminal and civil based on the nature of the punishment imposed. Civil contempt is a conditional punishment intended to coerce the contender to comply with the court order. By contrast, criminal contempt imposes unconditional punishment for prior contempt to preserve the court's authority and to punish disobedience of its order. And we saw that on Monday last week when Judge Glanville said that Attorney Steele could purge himself from the contempt if he just revealed his source. So the judge does not know the difference between civil and criminal contempt. After 30 years on the bench, he has no clue, which is scary. The contempt alleged by this court of, quote, disclosing information from the ex parte conversations to members of the defense counsel, end quote, could only be criminal contempt. Nothing can be done to purge or undo that allegations that alleged contemptuous act, and any punishment would amount to criminal contempt. A. No contemptuous conduct occurred. Then neither is, nor was, anything preventing the disclosure of this ex parte meeting to defense counsel. Disclosure did not violate the court order. There is no standing order in place or trial order that bars or in any way limits defense counsel for witnesses or any other individuals present at the ex parte meeting from communicating with defense counsel for the defendants about the meeting and its contents. And here is footnote 4. Even if a protective order were in place that barred participants in the ex parte meeting with a sworn key witness from notifying defense counsel, such an order would deprive the defendants of their due process rights. Ex parte communications are presumed to have been in error. That's not even the bar set. That is the standard. Ex parte meetings, unless justified, have been in error. Yeah, we went through this same thing in the steel motion. To the extent that this show cause order may be subject to a general demur, the order cannot pass this test. Assuming as true the allegation of disclosing information from the ex parte conversations to members of the defense counsel, contemptuous conduct is not alleged. Furthermore, contempt may be found only where the attorney knows or reasonably should be aware, in view of all the circumstances, especially the heat of controversy, that he is exceeding the outermost limits of his proper role and hindering rather than facilitating the search for truth. Here are more footnotes. Disclosure of the meeting did not exceed the limits of anyone's proper role. If anything, the disclosure facilitated the search for truth. Exactly. A judge may reasonably expect its clerks and other judges to keep what happens in chambers professionally private. However, they are under no legal duty to do so. Such an expectation of privacy does not extend to third parties, not part of the court staff. Yeah, you heard the judge said the sanctimonious privacy of my chambers. Fuck off! Oh shit! I said fork, YouTube's fork. It's my accent. I say Swedish words and my pronunciations in English. Sometimes they sound like other things. A judge may reasonably expect his clerks and other judges to keep what happens in chambers professional and private. However, they are under no legal duty to do so. Such an expectation of privacy does not extend to third parties, not part of the court staff. Holding an ex parte meeting in chambers did not impose a duty of secrecy. Informing counsel for defense of the existence and content of this chambers meeting did not violate any rule of law, trial order, or standing order, and is not the basis for contempt. The show cause order failing to articulate an act of contempt should be quashed. And Judge Glanville said he will address that after Mr. Copeland's direct examination, which will be, I don't know. And this is the judge must transfer this contempt matter to another judge. We went through this with the steel motion, so I can skip that. Here, the alleged contemptuous conduct was as expressed by the court, directed at least in part towards the court personally and the sacrosanct nature of its chambers. The court became involved in the controversy both by holding the ex parte meeting in the first place and by way of the fact that this court is a witness to the potentially disputed fact of whether there was ever any kind of order to not disclose the meeting to counsel for the defense. Yeah, judge need to show in that transcript. He actually said it. Here's the thing. I don't trust him. He could make shit up. And then Georgia Code of Judicial Conduct dictates a recusal because the court's impartiality might reasonably be questioned. We already went through that. I'm interested in more facts here. Here the court's impartiality might reasonably be questioned for 5 reasons. First, this court stated, "This is so sacrosanct to have a conversation in my chambers carried to you and others. It is that serious," revealing that this court views the harm to be at least in part a direct harm to this court personally and or the sanctity of his own chambers. Second, as described in the show cause order, some of the other participants in the ex parte hearing were the court's own security personnel. This gives rise to 2 issues. As potential witnesses, they may testify at the hearing, at which time the presiding judge will have to assess their credibility of the testimony. It might reasonably be questioned that this court would give more credibility to the court's own security personnel than it would to other potential witnesses, such as Attorney Bumpus. Further, the court's own security personnel and reported like attorney bumpers are subject to potentially being held in contempt. These courts impartially might reasonably be questioned if they were to sit as both the prosecutor and fact finder when deciding if it was the court's own security personnel and reporter, someone else who disclosed the meeting. Third, this court has personal knowledge of a disputed evidentiary fact, of whether there was an order of any kind barring disclosure of the meeting to counsel for the defense. Fourth, this court appears to already have decided prior to any hearing that it was Attorney Bumpers who made the disclosure. While holding Attorney Steele in contempt, this court stated, well, that other than if you, Attorney Steele, unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left. And if that person gave you that information or shared that information with you, she probably violated privilege. This judge doesn't understand attorney-client privilege. He just don't, or he don't care. This court's show cause order reinforces this predetermination as the order references no other person present at the meeting by name other than Attorney Bumpers or Copeland. Fifth and finally, the court was visibly impacted when it learned that Attorney Steele had been informed of the meeting. The Georgia Supreme Court referenced an opinion echoing this case in noting when a recusal motion clearly has merit. But what if the motion to recuse has merit? What if the judge who announced an oral ruling is, or reasonably appears to be, partial or prejudiced, and therefore has no business continuing to preside over the case? See Georgia Code, Judicial Conduct, Rule 211. What if, for example, a party defending himself at a contempt hearing turns around and accuses the judge of this, and the judge actively defends himself and then orally holds the accusing party in contempt? Explaining that argument over recusal issues may draw the judge into presenting his side of the story, which in turn may create a perception that the judge is an advocate or hostile witness rather than an impartial adjudicator in the case, requiring disqualification. This alleged contempt is not ongoing and does not require immediate resolution. This court has ample time to transfer this case to another judge who was not involved in the ex parte proceeding, who is not a potential witness to a potentially disputed evidentiary fact, who does not view the harm to be at least in part a direct harm to that judge personally and or the sanctity of the judge's own chambers, and who is not called to determine whether that court's own security personnel or reporter committed the alleged contempt, and if so, that punishment to impose. I think and Mignola today, and John and everybody. I don't know how much more I have of this, and then I will scroll through the chat to see if there are any questions I can answer. C. The court must provide a notice that fairly and fully informs the accused of the specific acts of contempt. When a contempt proceeding is criminal, the full panoply of constitutional protections must be afforded the accused. See all these cases. This includes a notice, quote, fairly and fully inform the accused of the specific act of contempt, end quote. This requirement of reasonable notice in a case involving an alleged indirect contempt contemplates and necessitates a written notice fairly and fully informing the accused of the specific acts of contempt with which she is charged, and so given as to afford a reasonable time to make her defense. Any notice short of that would make a hollow mockery of the fundamental and abiding truth that reasonable notice to one's whose civil rights or personal liberty may be affected is a veritable cornerstone of our judicial system. Will constitute nothing more than an exquisite exercise in frustrating futility, sometimes misleading and always meaningless, and would be but sounding brass and tinkling cymbal. A notice in form, but not in substance. And a lot of case law here. As said, well, fourth above, the act of disclosing the meeting to defense counsel cannot in and of itself amount to contempt. The disclosure could only potentially amount to contempt if it violated a court order or some other legal duty to not disclose the ex parte meeting. The notice fails to allege any such restriction. As such, the notice fails to fairly and fully inform the accused of the specific act of contempt. Wherefore, Attorney Bumpers would this court to quash its order to show cause, or in the alternative, recuse itself from the proceeding and or transfer his proceeding to another judge whose impartiality can't reasonably be questioned, or in the alternative, provide an adequate notice that fully and fairly informs Bumpers of the alleged contempt. Should all of the above requested relief be denied, Attorney Bumpers request a certificate of immediate review. And we know that the judge doesn't do that. He refuses to have anything going to the appeals court mid-trial because he's corrupt. Submitted attorneys certificate of service. Order, this is the judge's order to show cause. Affidavit in motion to recuse Chief Judge Judge Glanville. Let's see here. No, this is just a reiteration of what is. This is just a short form of what we just went through. And okay. So that was Mr. Steele's and Ms. Bumpers. And in my opinion, but I'm I'm clearly biased against the judge, so I will have to refer that final decision, hopefully sooner or later, to the Georgia Supreme Court, because this is insane. Folks. It is beyond insane that Judge Glanville can have the power to do this. That calls in question, should a judge have the power to not approve? I mean, a rule and a law and a statute is only good if a judge approves of it, listens to it, abide by it. And Judge Glanville clearly does not give two shits on a straw about due process, the Constitution, the Bill of Rights, anything, as long as he can preside over this case and take it to conviction. Now let's see. Any good questions here? Robert Levy, the GA Judicial Qualifications Commission has already started an investigation into the allegations of judicial misconduct by Judge Glanville. That is good to hear. I heard that same, whose channel was it? I don't remember. That even if they start that, it will take months. That's thank you, Robert. Let's see. Getting to your Supreme Court is stepping out. Oh, Jesus Christ. And if you have any questions, write it. Write down your questions in the chat. They are still on break. Nobody's surprised that this 15-minute break has been going on for over half an hour now. Stabbing. I should have launched over the bench like I do last year. No. Okay. Nothing. Yes, court is on break. Okay. 2 hours and 5 minutes in. We know they are going to spend the rest of the day showing videos. And for you who don't know, I had negotiations this morning, my time, and I managed to get away from it at lunch so I could drive home and start the stream, but I have to go back tomorrow morning. So yeah, I started 5 a.m. this morning, my time. I drove up to the place of the negotiations. I was there at 8. Negotiations started at 8:30. Broke at lunch. I asked if it was okay that we take it up tomorrow, which was okay. So 3 hours there and back, and the same tomorrow. Yeah. Tomorrow is Juneteenth. I don't know if there will be court tomorrow. I have no idea. If it isn't, I'm going to do recaps of whatever videos was shown today and yesterday, so we can get at least my interpretation and my snark and tomfoolery. And I know, Ghost, hold on. And Mr. Jingles. Hello, Mr. Jingles. He's so happy when I do this, showing him to the world. Look at that happy face. Look at that happy face of Mr. Jingles. He does not tend to end me at all. All right, but what else can I say? Sadly, today was not Yeet the Judge Day. He did not recuse himself. It's a national holiday tomorrow. Okay, so no, I assume no court tomorrow. Then I will do recap of sorts of the situation that has occurred since Mr. Woody took the stand. So we get a more concise, no, a more trimmed down stream about it. But it's 5:37 p.m. my time, and I need to get some work done before I go to sleep and return to that negotiation tomorrow morning. So, folks, I'm going to yeet you over. Since we can't yeet the judge, I'm going to send you over to somebody whose trial is still ongoing. Who would that be? Would that be? Legal vices. Yeah, I haven't gotten people over to him in a while. So, come on. Save. Save. Come on. Stream customization. Redirect. Oh, come on, come on, come on. Nope. Oh! Yeah. The device is still on. Come on. There. All right. I will be sending you off with the song. Not. Oh, I'm not going to sing. Oh, hell no. I'm not going to sing. What should I do? Dun, dun, dun. Yeah. Let's do this one. I'll see you all back here tomorrow. Bring friends. Hit the thumbs up. And say hi to Jeff for me. All right? Bye-bye.